Good afternoon, everyone. On February 22nd, 2021, defendant Sharon Har was driving the wrong way against traffic on Beretania Street. She was stopped, eventually arrested for operating a vehicle under the influence of an intoxicant. I want to commend the professionalism and the courtesy at all times of the Honolulu police officers involved in this case, as well as all the other state's witnesses. Now let's take a look at the charge and the evidence and what happened in court. So this is the charge. 291E61 HRS, operating a vehicle under the influence of an intoxicant, what used to be called a DUI. And a person commits the offense of operating a vehicle under the influence of an intoxicant if the person operates or assumes actual physical control of a vehicle while under the influence of alcohol in an amount sufficient to impair the person's normal mental faculties or ability to care for the person and guard against casualty. That is what was charged in this case. Subsection 2 refers to driving under the influence of drugs. Subsection 3 refers to having 0.08 or more alcohol in your breath, and 4 is 0.8 or more grams of alcohol in your blood. But what was charged in this case is what's called an A1, driving while under the influence. Sergeant Adam Lipka, he stopped Ms. Har at the intersection of Beretania Street and Pi'ikoi on February 22nd, 2021 at 10:06 p.m. Both Beretania and Pi'ikoi are one-way streets. So just to get everybody oriented, this is Beretania Street headed from Cocoa Head toward Eva. It's one way toward downtown. It intersects here with Pi'ikoi, which runs from the ocean to the mountains, from Makai to Mauka. This is where the officer's car was at the first instance. Over here is where Ms. Har's car was, in the middle lane. The officer then pulled up and directed her to pull into the parking lot of Territorial Savings over here. In doing that, as she was driving, she almost hit a moped, and she caused other cars to swerve and get out of her path. Instead of pulling into Territorial Savings, Ms. Har tried to make a right turn onto Pi'ikoi, heading into oncoming traffic. But Sergeant Lipka very alertly pulled his vehicle in front of her, blocking her from making that turn. He then got in his loudspeaker and told her to pull into the parking lot for Territorial Savings. Now, even though, as he testified, she could have made it in one sweep, one turn to get into the parking lot, it took her several back and forths to do it. Now, Sergeant Lipka also testified that she looked confused. That, as I said, she reversed back and forth multiple times in order to make that turn. She then parked her vehicle in the Territorial Savings parking lot, but failed to park it within the lines of a parking stall. He testified that she smelled of alcohol. She said, Ms. Har said, she came from Any Place Restaurant. Its real name is Any Place Cocktail Lounge. He then asked for registration and insurance information. She produced an expired vehicle registration card. She then looked at her phone for over 10 minutes, apparently trying to find some insurance information on that. without success. But the officer was very patient, letting her try to go through her phone. At least that's what we're assuming. She was looking for insurance information. Now, let's take a look at briefly where both Any Place Cocktail Lounge is and where the incident took place. Here is the intersection on the left of the screen of Beretania and Piikoi. All the way on the right of the screen is the Any Place Cocktail Lounge. It's on the ocean side of King Street, just Cocoa Head of McCully. Now, this is where she was before drinking. This is where she was stopped 45 minutes later. Scary. Now, Officer Danilo Ting also testified. He testified that Ms. Har had a strong odor of alcohol, that she refused to take the standardized field sobriety test, that she tried to roll up her window or raise her window, open her door, and get out of the car when she wasn't instructed to do so. She also said she was a spaz multiple times. Now, the prosecutor investigator, Tommy Kong, testified, and he introduced a video of Ms. Har several days after the incident, apologizing to her House colleagues, talking about having a respiratory infection, working long hours, taking medication, and drinking a beer with dinner.
Thank you very much. Representative Har.
Thank you, Mr. Speaker. Mr. Speaker, if I may address you and the body for 1 minute, I would appreciate it.
Yes, absolutely, Representative.
Thank you, Mr. Speaker. Mr. Speaker and colleagues, I wanted to address an incident that occurred on Monday, February the 22nd. As I'm sure you've all heard by now, I was arrested for suspicion of driving under the influence. I wanted this opportunity to explain to you what exactly happened that evening and to apologize to this body. It's important for all of you to know, I have been sick. I've been ill for several weeks now. I've been battling a respiratory illness and have been on prescription medication. I did work late that night. I've been working late on several projects in my private sector job. And after working late that night, I made the decision to have a beer with dinner. While I didn't realize it at that time, it's obvious that that decision, coupled with my medication and my long work hours, was something that I will regret for the rest of my life. Mr. Speaker, as a freshman, I was always taught by our predecessors, our elder statesmen, that regardless of differences, political, personal, professional, or philosophical, above all, the institution comes first. The House of Representatives is an institution which we all have the privilege of serving. Mr. Speaker, I want to deeply apologize to you, the members of this body, for any embarrassment and shame I caused to you, my colleagues, and the institution. Thank you to the members who have reached out to me with your thoughts, your prayers, and your kind words of support. I remain fully committed to regaining your trust and confidence as a member of the House of Representatives, the legislature, and your colleagues. Thank you for this opportunity to speak.
Okay, let's take a look again. This is the Any Place Cocktail Lounge, and over here is the Beretania-Piikoi intersection. Now, Ms. Har may not be familiar with the back streets of the McCully-Mo'iliili area, but where this took place at the corner of Beretania and Piikoi is in the middle of town, and it's about 6 blocks away from where she had been working for the past 15 years at the state capitol. Now, prosecutor investigator went down to Any Place Cocktail Lounge and interviewed witnesses there. The server, bartender server, testified that she served Representative Har's table during that evening, that Ms. Har had ordered 4 Miller Lite in 12-ounce bottles and was seen drinking from them. The invoice, which you'll see in a moment, showed 4 orders for Miller Lite. It was a party of like 5 at the table. And the bartender server confirmed that only Ms. Har drank the Miller Lights. Now, this is a little hard to see, but you do have a copy of it in the PowerPoint that's been handed out to you. And as you look through it, you can see that, in fact, there were 4 Miller Lights that were ordered, and that Ms. Har was the only one drinking the Miller Lite. Now, again, let's look at the charge. You're operating a motor vehicle while under the influence of alcohol in an amount sufficient to impair the person's normal mental faculties or ability to care for the person and guard against casualty. Now, what did the evidence show here? That Ms. Har went to any place, cocktail lounge, and was served 4 Miller Lights. Less than an hour later, she was caught driving the wrong way on Baratania Street, that she almost hit a moped. Other vehicles had to move to get out of her way. HPD alertly stopped her at that point, directed her to a parking lot. She tried to take a right turn onto a second one-way street opposing traffic. The officer was able to block her with his car. She was asked for her registration and insurance. She provided an expired registration, and she took over 10 minutes looking in her phone, apparently looking for insurance information without success. She refused to take the standardized field sobriety test, and she was arrested for DUI, or OVUII. So at this point, the state rested. Now, first, the defendant made a motion to dismiss, an oral motion to dismiss under State versus Thompson regarding the form of the complaints. We've had a number of those motions heard in court. We had followed the Intermediate Court of Appeals ruling on that. More recently, the Supreme Court came out with a different ruling. But what's important here is, as the deputy prosecutor correctly argued, pursuant to Hawaii Rules of Penal Procedure, Rule 12B, motions to dismiss due to defects in the complaint need to be raised prior to the trial, because then they can be dismissed without prejudice, which is what is happening routinely when they are brought up, and then the prosecutors have a chance to bring it back. Here, it was dismissed after jeopardy attached in a trial, so it could not be brought back. The deputy also then pointed out that under Hawaii Rules of Penal Procedure 12F, the failure to raise the motion prior to trial constitutes a waiver of the ability to do so. So given the fact that the defense failed to raise this motion prior to trial, the motion should not have been heard at that point, and it should not have been granted. Next, the defense brought a motion for judgment of acquittal. Now, a judgment of acquittal is something that is raised in virtually every single case. The defense doesn't want to be accused of not fulfilling their duty, of ineffective assistance, so they raise it in every case. It is virtually never granted, because when you grant a motion for judgment of acquittal, what you're saying is the case never should have been brought to begin with. And in my 16 years as a prosecutor, I never lost a case based on a judgment of acquittal, or I never got JA'd, as we say. And in my 15 years on the bench, I never granted a motion for judgment of acquittal. Like I say, the defense counsel bring it up, they ask to approach, they're up at the bench asking for a judgment of acquittal. And here's the standard the court is supposed to follow, whether it's circuit court or district court. The standard to be, and this is from State versus Alston, the Hawaii Supreme Court. The standard to be applied by the trial court in ruling upon a motion for a judgment of acquittal is whether, upon the evidence viewed in the light most favorable to the prosecution, and that's critical, and in full recognition of the province of the trier of fact, so judge or jury, judge or jury, a reasonable mind might fairly conclude guilt beyond a reasonable doubt. So the judge is supposed to look at all the evidence and in the light most favorable to the state, which means if they're conflicting statements, they should be viewed in the light that favors the state. And decide then whether a reasonable mind might decide guilt beyond a reasonable doubt. Not that that judge necessarily would do it. My guess is Mr. Luke had no idea it would be granted. He's been a former prosecutor. He's an experienced attorney. He could see the strength of this case. But he's doing his job by requesting it in every case. So let's look at what the evidence that the judge should have been looking at to make this call. Again, in the light most favorable to the prosecution for a judgment of acquittal. Serve 4 beers at Any Place Cocktail Lounge. Driving the wrong way on Baratania Street. Attempting to drive the wrong way on Piakoi Street. Strong odor of alcohol. Refused to take a field sobriety test. And failed to locate her insurance card even though she looked through her phone for more than 10 minutes. The state believes that a reasonable mind might fairly conclude guilt beyond a reasonable doubt and that the judge should have so ruled. Now, the defense brought the motion to dismiss pursuant to Thompson. Based on the defendant's failure to comply with Rule 12, this was in error. The defense then brought a motion for judgment of acquittal, which the judge granted. The judge said this ruling was because of inconsistencies in the officer testimony and the lack of blood alcohol content meant the state couldn't prove the case beyond a reasonable doubt. This does not follow the appropriate standard for a judgment of acquittal. Inconsistency in an officer's testimony should be resolved in the light most favorable to the state. And the lack of a BAC reading should not have been brought up at all, especially in this case because Ms. Har refused to take a breath test. On the evening of February 22nd, 2021, the evidence showed that Ms. Har was a danger to herself and to anyone else out on the road, car or pedestrian. Anyone driving the wrong way on a one-way street when other cars are there, when there are lights facing you from the other direction, is a danger to themselves and others. I don't want to speculate on how the driving was between Any Place Cocktail Lounge and that intersection, but it's some distance across Honolulu streets. And to say that her normal mental faculties or ability to care for herself and guard against casualty was not impaired defies common sense, according to the evidence. I want the public, though, to be reassured that HPD and the prosecutor's office will not be deterred by the outcome in this case. We will continue to work together to hold people accountable and keep our streets as safe as possible. No one is above the law. And all we would ask is that judges follow the law and give us a level playing field in court. Are there any questions I can answer? Yes.
So Steve, yesterday you said you were disappointed with the decision, but it sounds like you're just saying you weren't given a level playing field and that basically the judge got it wrong, the per diem judge got it wrong.
Yes, I was disappointed and I think the judge got it wrong. That's absolutely correct. Yeah.
Is there any action you can take against the judge?
Not to overturn the results of this case. We have to live with this. Yeah.
Are there any consequences in the state of Hawaii for refusing a test like that?
Yeah, you get your license suspended typically for a year.
Is that what's happening in this case?
That's what the law tries to encourage people to take the test by suspending their license for a year.
Do you think a 1-year deterrent is enough?
I don't know. Cases like this make you wonder. But that's what it's been so far. It's been that way for quite a while. The idea is that if you know you're going to lose your license, take the test. If you think you're going to pass the test, take the test. If you've only had one drink, take the test. Yes?
Steve, Howard Luke told me yesterday that she made a mistake. She was driving the wrong way. She lives in Kapolei. She doesn't know the streets very well. Your reaction to that?
He's a defense attorney. He's trying to explain this away. The stories we hear that you folks report about people driving the wrong way are often horrendous. You get into horrible traffic accidents. If somebody's coming at you in the wrong direction, you as a driver may be steering to avoid them. You don't know which way that other driver is going to turn. You may go to the right, they go to the left, you still hit each other. So it's really dangerous. And I appreciate that she may live in Kapolei and she may not know the details of small streets around any place, a cocktail lounge. But this is in the center of town. This is a busy area. You can see on the body cam footage cars driving by routinely. This is a busy area. And like I said, it's about 6 blocks from where she has been working for the last 15 years. So to say that she's unfamiliar with the area seems unlikely. Yeah.
What is the explanation? How can a judge get it so wrong then?
Your guess is as good as mine. I don't understand that because the judgment of acquittal, I was used to doing that for 15 years as a judge. You view the light most favorable to the state, and in that case, you're almost never going to grant it because for you to grant it, like I said, means it never should have been brought to begin with. You can't even make a prima facie case. You can't make out the elements of a case. So I was really surprised to see that outcome. Maybe shocked would be a better thing. That's a different story than proof beyond a reasonable doubt at the end of the case. But to have that, we still thought we had a strong case there, being served for driving wrong way. Anybody driving the wrong way on a road like that, seeing cars coming toward them, there's something really wrong going on. And, I think that just screams impairment. So for that to happen, but in particular at this stage, at a motion for judgment of acquittal, where you're supposed to look at, and the judge said there are inconsistencies. Well, you're supposed to resolve those in the favor of the state, looking at the evidence in the light most favorable to the state. So I don't understand it at all.
So is that the only consequence that she faces losing her license? Did she have to go through any other?
Nope, she was acquitted of this operating a vehicle under the influence of intoxicating liquor.
Have that device built into her vehicle?
Nope. Nope.
The vehicle impounded?
And this is not to denigrate at all the effort she's made over the years in this area. She's been a real proponent of it, I guess, since she got hit by a drunk driver. I believe it was back like 2007, something like that. And she's been a real strong proponent of DUI laws at the legislature. But this is the evidence we have in front of us. This was the evidence that was presented in court recently and then again yesterday, and this is the result we have. Yeah.
Would you dare to suggest that this is politically motivated, or here's a woman in a powerful position that perhaps the judge? I mean, why else would this?
I can't speculate. I'd hate to think something like that would be a part of it.
There's this whole technicality thing that's still out there, I guess, right? I mean, what are you going to do to resolve that? I guess that's still
Well, we're still working on that. We've talked, with folks in the legislature. I think they're looking at clarifying the law in addition. But our big beef here was, first, the ICA was overruled by the Supreme Court, but the fact that it never should have been brought up during the middle of trial. Jeopardy had attached. That is wrong. A request to bring that up. I'm sorry, Mr. Luke. you're untimely, and because you didn't raise it before, it's waived. So it never should have been heard, never should have been granted.
Even if the decision wasn't made until after jeopardy attached, like in this case?
It should be dealt with ahead of time, primarily because if it is granted, it is virtually always without prejudice. That gives us the opportunity to refile. So that should happen before jeopardy attaches, because once that happens, you can't unring that bell. Okay? Yeah.
Is there something, perhaps the judge is inexperienced? I mean, I don't know. Is there any reason that this could have gone past him?
I don't know. I don't know.
Do you have an issue with per diem judges?
Not in general. You know, they're playing an important role in order to fulfill spaces that need to be taken. I have a division chief who was a per diem judge, Flo Nakakuni, who was the U.S. Attorney after me. It's a great opportunity for people to get some experience and contribute, and the judiciary needs the work of per diem judges. There's no question about it. Okay, one more question? Yeah.
So just to clarify, right? You said that this office and HPD will not be deterred from these cases, but we have to live with this. So there's nothing else that you guys can do.
Yep, we will keep working together. We will try to get as creative as we can, think outside the box. Drunk driving or driving under the influence is a tremendous problem, and a lot of people get killed every year with it. And we want to make those numbers as small as possible. So we'll keep working with HPD. You know, I used to be a judge. I know, they get the final say in what happens in court, and we're just going to have to live with it. But we will keep working with HPD, and we'll do our level best to keep the streets as safe as possible. Okay, thank you.